Hi friends, in this video we are going to deal with this case summary of the important and latest Supreme Court judgments pronounced now in the area of negotiable instruments. To know more about it, please watch the video fully.
The next important judgment titled Dilip Hariramani versus Bank of Baroda, pronounced on 9th May 2022. In this judgment, the Supreme Court has held that a person cannot be convicted for the offence of dishonor of cheque under Section 138 of Negotiable Instruments Act merely because he was a partner of the firm which had taken the loan or that he stood as a guarantor for such a loan. The fact of the case would be that the respondent bank granted term loans and cash credit facility to a partnership firm which in turn issued 3 cheques in part payment of loan. However, the cheques were dishonored on the presentation due to insufficient funds. The bank issued a demand notice under Section 138 of the NI Act. The bank filed a complaint against partners of the firm under Section 138 of the NI Act before the Court of Judicial Magistrate. The firm was not made an accused. After trial, the appellant and one more partner were convicted by the Judicial Magistrate under Section 138 of the NI Act and sentenced to imprisonment for 6 months. They were also asked to pay Rs 97,50,000 as compensation under Section 357 subsection 3 clause 4 of the Code of Criminal Procedure 1973 and in default suffer additional imprisonment for 1 month. On appeal, the appellate court modified the sentence awarded to the imprisonment till the rising of the court and at the same time enhanced the compensation amount under Section 357 subsection 3 from 97,50,000 to 1,20 lakhs, with the stipulation that the appellant and one more partner shall suffer additional imprisonment for 3 months in case of failure to pay. The appellant and the other partner challenged the judgment before the High Court of Chhattisgarh, which was dismissed by the impugned judgment. Being agreed, the present appeal has been filed. The Supreme Court has held that the burden is on the prosecution to show that the person prosecuted was in charge of and responsible to the company for conduct of its business. The proviso, which is in the nature of an exception, states that a person liable under subsection 1 shall not be punished if he proves that the offence was committed without his knowledge or that he exercised all due diligence to prevent the commission of such offence. The onus to satisfy the requirements and take benefit of the proviso is on the accused. Still, it does not displace or extricate the initial onus and burden on the prosecution to first establish the requirements of subsection 1 to section 141 of the NI Act. The proviso gives immunity to a person who is otherwise vicariously liable under subsection 1 to section 141 of the NI Act. Subsection 2 to section 141 of the NI Act does not state that the persons enumerated, which can include an officer of the company, can be prosecuted and punished merely because of their status or position as a director, manager, secretary or any other officer, unless the offence in question was committed with their consent or connivance or is attributable to any neglect on their part. The onus under subsection 2 to section 141 of the NI Act is on the prosecution and not on the person being prosecuted. In the present case, it is an admitted case of the bank that the appellant had not issued any of the 3 cheques which were dishonored, in his personal capacity or otherwise as a partner. In the absence of any evidence led by the prosecution to show and establish that the appellant was in charge of and responsible for the conduct of affairs of the firm, the appellant cannot be convicted merely because he was a partner of the firm which had taken the loan or that he stood as a guarantor for such a Note: the Partnership Act 1932 creates civil liability. Further, the guarantor's liability under the Indian Contract Act 1872 is a civil liability. The appellant may have civil liability and may also be liable under the Recovery of Debts Due to Banks and Financial Institutions Act 1993 and the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. However, vicarious liability in the criminal law in terms of Section 141 of the NI Act cannot be fastened because of the civil liability. Vicarious liability under subsection 1 to section 141 of the NI Act can be pinned when the person is in overall control of the day-to-day business of the company or firm. Vicarious liability under subsection 2 to section 141 of the NI Act can arise because of the director, manager, secretary or other officers' personal conduct, functional or transaction role, notwithstanding that the person was not in overall control of the day-to-day business of the company when the offence was committed. Vicarious liability under subsection 2 is attracted when the offence is committed with the consent, connivance or is attributable to the neglect on the part of a director, manager, secretary or other officers of the company. The demand notice issued by the bank through its branch manager was served solely to the other partner who was the authorized signatory of the firm. The complaint under section 138 of the NI Act before the Court of Judicial Magistrate was made against the other partner and the appellant. Thus, in the present case, the firm has not been made an accused or even summoned to be tried for the offence. Unless the company or firm committed the offence as a principal accused, the persons mentioned in subsection 1 or subsection 2 would not be liable and convicted as vicariously liable. Section 141 of the NI Act extends vicarious criminal liability to officers associated with the company or firm when one of the twin requirements of section 141 has been satisfied, which persons then, by deeming fiction, is made vicariously liable and punished. However, such vicarious liability arises only when the company or firm commits the offence as the primary offender. Thus, the impugned judgment of the High Court confirming the conviction and order of sentence passed by the Sessions Court and the order of conviction passed by the Judicial Magistrate are set aside.